Good evening, everyone, and thank you for joining us this evening. My name is Damon Hewitt, President and Executive Director of the Lawyers Committee for Civil Rights Under Law. I want to welcome you to this important virtual event, the new SCOTUS term, 3 Key Cases You Need to Know About, brought to you by the Lawyers Committee for Civil Rights Under Law. This year marks the 60th anniversary of the Lawyers Committee's founding. As many of you know, we were founded at the height of the Civil Rights Movement in 1963, that pivotal summer just before the March on Washington and that pivotal summer of 63. Today, we work inside and outside the courts to achieve racial justice. Our work helps to ensure that Black people and other communities of color have the voice, the opportunity, and the power to make the promises of our democracy real. 6 decades of fighting for civil rights have brought us to this pivotal moment in our nation's history, a time when the very fabric of our democracy is being tested. The urgency of our mission is as relevant now as it was when we were founded. That's why we've convened this panel of distinguished experts to discuss 3 potentially landmark cases that are before the U.S. Supreme Court this term. These cases are not just legal disputes. They may be defining moments that will help shape the future of civil rights, racial justice, and social justice in America. We're not here to spread fear about what may happen, but to arm you with the facts and the analysis and the insights, because we know that knowledge is our strongest weapon in the fight for justice. I want to highlight that 2 of our panelists, Leah Ayton and Kelsey Corcoran, just argued cases before the Supreme Court last week. First, Leah Ayton, formerly Deputy Director of Litigation at NAACP LDF and now Senior Counsel, brings her fresh experience arguing the South Carolina redistricting case, Alexander versus Carolina State Conference of the NAACP. It was her debut before the U.S. Supreme Court, and she did a marvelous job. Kelsey Corcoran, the Supreme Court Director at the Institute for Constitutional Advocacy and Protection, is the arguing counsel in Akeson Cotels versus Lawford, a key case about standing and what I like to call access to courts in the first place when it comes to matters of civil rights. Deepak Gupta, founding principal of Gupta Wessler, will discuss the Consumer Financial Services Association of America versus Consumer Financial Protection Bureau case, CFPB case. Deepak is a Supreme Court expert. He also is a board member with us at the Lawyers Committee. Now, these cases touch on voting rights, the ability of civil rights testers to file lawsuits, and consumer protection. Each of these cases has the potential to reshape the civil rights landscape in profound ways. They're part of a broader tapestry of civil rights issues that we at the Lawyers Committee are committed to defending, along with many of you. We're not just reacting to the moment, we're building a future that honors the dignity and worth of every American. That's why these cases are so important. I want to note that the Lawyers Committee did file amicus briefs in all 3 of these cases because as an organization, we understand what is at stake. And we're hosting this event tonight because we also want you to be clear about what's at stake. So you'll hear from the experts. Tonight's important discussion is really just a starting point. We want to understand not just the law as it stands today, but also envision what the law could be, what we want it to be, and what we need for it to be, frankly. We must use what we discuss here tonight to fuel the action that we take moving forward. Let's use the opportunity to move from a mindset of limitation to one of possibility. So as you listen to our panelists, I urge you to remember that we are the capable architects of our own liberation. We're responsible for doing whatever is necessary to build the future that we deserve. Now, lawyers don't always lead movements, but when movements need a lawyer, they know who to call. And that's many of our panelists and our speakers here tonight. I want to thank you for being here, and I look forward to this stimulating and enlightening conversation. Now, I'm honored to share this virtual stage with our panelists, but also with tonight's moderator, my colleague, John Greenbaum, Chief Counsel here at the Lawyers Committee. John, the floor is yours.
Thanks, Damon. That was a great introduction. The genesis from this for this panel came from something that Damon mentioned, the fact that the Lawyers Committee increasingly seems like is getting involved and participating as amicus in Supreme Court cases because so many of these cases now involve civil rights and racial justice issues. And for the first 2 weeks of this court term, there happened to be 3 cases in which we filed amicus briefs. And those are the 3 cases that we're going to be discussing tonight. And we're so privileged, as Damon mentioned, to have for 2 of the cases, the oral advocates in those cases. And for the 3rd case, somebody who knows the CFPB And the combination of the CFPB and Supreme Court practices as much as anybody. So they were all our first choices. We're so glad to have them. We're gonna go in order of the three cases that we're going to be discussing. I'll introduce each of the panelists briefly, and then we're going to go into detail, both in terms of talking about the panelists and each case one by one. After that, we're going to have a couple questions for the panelists as a whole to discuss, and there's going to be the opportunity to answer questions that you all have asked. So please use the Q&A tool if you have questions for any of our panelists, and we'll try to get to them during the last part of our discussion. So as I mentioned before, three panelists. First is Deepak Gupta, who's going to be talking about Consumer Financial Protection Bureau versus Community Financial Services Association of America. Deepak is the founding principal of Gupta Wessler, which in the last decade, since he founded, has become a real force when it comes to issues of consumer protection and issues of appellate law, particularly on what's typically the plaintiff's side. Prior to that, Deepak did work at CFPB during its early years and was involved in creating some of the litigation structures at CFPB. And then he got started at public counsel with the Supreme Court practice there. And Deepak's argued several times at the Supreme Court and has had some significant victories. And I might as well introduce the two other panelists now too. Kelsey Corcoran is going to talk about Atchison Hotels versus Lawfer. And Kelsey currently is the Supreme Court director at the Institute for Constitutional Advocacy and Protection and a senior lecturer at Georgetown. Kelsey has a variety of experiences, both in public and in private. She worked in the appellate division at DOJ. Her job prior to ICAP, and the first time that I met Kelsey, was when she was the head of the Supreme Court practice at Orrick, Harrington, and Sutcliffe. And Kelsey's argued a number of cases before the Supreme Court with a lot of success, including before the current version of the Supreme Court, the mostly current version of the Supreme Court. And Kelsey and Deepak are two people that when I have questions about Supreme Court practice, I often go to. And then our final panelist is Leah Aden, who, as Damon mentioned, is senior counsel at LDF. Leah is one of the leading voting rights lawyers in the country. During her early days in terms of doing voting rights, she had the opportunity, along with me, to work on the Shelby County, the infamous now Shelby County versus Holder case. And in the last decade since at LDF, has worked on a variety of matters, including stuff that is not voting rights. But I know Leah is a voting rights lawyer, and she argued Alexander versus South Carolina NAACP. So why don't we now get into talking about the first case of the three, CFPB versus CSFA. So Deepak, what is at stake in Consumer Financial Protection Bureau versus Community Financial Services Association of America?
Hey, John, thanks for having me here. Your bio of me missed my most important qualification, which is that 2 decades ago, I was John's intern at the DOJ voting rights section. So what's at stake in this case? This is a big case about the constitutionality of this agency that I used to work at, the Consumer Financial Protection Bureau, and in particular, the constitutionality of its independent funding structure. The question is whether that structure violates the appropriations clause of the Constitution. And for those who don't have their pocket constitutions out, or you forgot what that clause says, it says no money shall be drawn from the Treasury, but in consequence of appropriations made by law.
Thanks, Deepak. So why should advocates of civil rights and racial justice care about this case?
Well, because the Bureau has a lot of work to do that's very central to civil rights. the Bureau enforces and interprets the Equal Credit Opportunity Act, which is the signature law that protects Americans from racial discrimination in the markets for auto loans, mortgages, credit cards, and a lot more. So it's a key watchdog against discrimination that affects people's ability to buy homes, cars, and all the products and services that we need. And the Bureau is just hugely important for all Americans, but especially for those with less economic power. This is an agency that has returned over $17.5 billion to Americans who are ripped off.
Can you talk a little bit? You mentioned before that this case is about the appropriations clause and how the CFPB is funded. Could you talk a little bit about how the CFPB is funded? And then how is that funding structure similar and different than other governmental agencies? And why does that matter in this case?
Yeah, so as folks may recall, this is the agency that was the brainchild of now Senator and Professor Elizabeth Warren. And it was created after the 2008 financial crisis to be an independent watchdog for the American consumer. And one way to make sure that the agency was a truly independent watchdog, Congress thought at the time, was not to fund it with the typical kind of annual appropriations, because that would mean that there would be a whole lot of campaign contributions that would be directed at, the agency's funding, and the agency could be captured. So instead, the agency gets its funding from the Federal Reserve's investments and from basically from money that the Federal Reserve collects from banks. And that might seem unusual, but it's not. A lot of financial regulators, the Federal Reserve, the Office of the Comptroller of the Currency, Federal Housing Finance Agency, a whole bunch of federal regulators get their revenue through similar means and not by ordinary appropriations. And so one of the big problems for the challengers in this case was to convince the Supreme Court that the CFPB is unconstitutional, but that all these other agencies are not.
So what is the Community Financial Services Association of America? Sounds, almost sounds like the CFPB in terms of its name.
Yeah, I mean, it sounds kind of innocuous, but what it really is, John, is it's basically a trade group for the payday lenders, for the payday lending industry. And this is one of the most predatory industries that is regulated by the CFPB. Their business model essentially relies on trapping people into cycles of debt. If you have an honest financial services business, you've got nothing to fear from the CFPB. The CFPB is about going after predatory practices like that.
And then what happened in the lower courts in this case?
Well, like several of the big cases in the U.S. Supreme Court this term, this case came from the Fifth Circuit. A panel of the Fifth Circuit ruled that Congress had run afoul of the Appropriations Clause when it established the CFPB. And they also went further and invalidated a new rule that the CFPB had put out to regulate payday lenders on the ground that the funding that went into the work to produce that rule was the product of an unconstitutional funding arrangement. And so there's this very sweeping ruling that called into question everything that the CFPB did, simply because the agency is not funded through an annual appropriation.
And then what did related to that, what did the court kind of issue as relief?
Yeah, I mean, it was striking down this payday lending rule. And there's really no limit to that kind of remedial theory. If the challengers are right about that, pretty much any rule from the CFPB, arguably to its inception, could be invalidated, which would cause enormous chaos in the markets.
All right, so we talked about this case being an appropriations clause case. In the Supreme Court argument, where did the justices appear to line up on the issue of whether there's a violation of the appropriations clause?
Yeah, so I mean, going into this argument, I think people were looking at the most conservative justices to see whether, the challengers' arguments found purchase. And this case was argued by Noel Francisco, who was President Trump's Solicitor General. And I have to say, listening to the argument, while they gave the Solicitor General, who did a beautiful job of arguing this case herself, while they gave her a hard time, it was very hard to see the votes lining up for the challenger's position. Justice Kavanaugh, who folks may remember, was the author of an opinion striking down the CFPB on other constitutional grounds when he was on the DC Circuit. He thought that he did not buy the challenger's position, that Congress really could change this arrangement tomorrow, and so it's not really a forever appropriation at all. Justice Barrett seemed like she was really struggling to figure out where Noel Francisco drew the line on his theory and did not seem terribly persuaded. Even Gorsuch jumped in at one point, Justice Gorsuch asking for Francisco's line and thought it was very unclear. So I do not see any clear votes for the challengers, to be honest, and I certainly don't see 5 votes.
So can you think of anything like this where the court has said that an agency that Congress created through legislation, that the creation of that agency violated the appropriations clause, and essentially, I guess the end result would be that it invalidated the agency's actions?
No, and in fact, the very first sentence of Solicitor General Prelogar's argument was that this is the very first time that any court has done what the court below did here, which is to invalidate an act of Congress that's a funding statute on the basis of the appropriations clause. It's really hard to overstate how much this is an aggressive, novel, conservative argument that was kind of an afterthought in the lower courts and was picked up by this very, very aggressive conservative panel below.
Back in the district court, in this, do you know in the district court's decision how much of this come from the Fifth Circuit? How much of this come from the district court?
It really all comes from the Fifth Circuit, and even in the briefing in the Fifth Circuit, this was not the principal focus. It really was. I don't want to. I don't say this lightly, but this was really, I think, an activist opinion by the panel below.
All right. So my last question was going to be, what is your prediction and why? But I think you've explained that already. So Deepak will be coming back to you later on for the questions that we're going to be asking all the panelists. So we're going to move on to Kelsey. I have to say, I've talked about this a little bit. This is one of the most unusual cases that I can think of procedurally in terms of where things were and how it got to the Supreme Court, what happened when it was at the Supreme Court. You weren't personally involved in this case in the lower courts, but you have a situation in which the Ms. Laufer's counsel acquiesced to cert. You very, very rarely ever see that happen. You have a situation where Ms. Laufer doesn't plan on bringing these cases anymore going forward, and you have a situation where on the other side, Atchison Hotels has sold the hotel in question, and so you have to wonder, why they're still in the case in the first place. So very, very unusual set of events. But notwithstanding that, what's at stake in this case?
So thanks for having me, John, and everyone here. So 2 answers to that. At a very specific level, there's the question of whether a disabled plaintiff who sues a hotel for not having accessibility information as part of its reservation service has to show that in addition to that discriminatory condition on the website, she was also kept from staying at the hotel, whether she has to show additional injury. The bigger question has to do with civil rights testing. And so this is, this goes back 65 years to segregation era challenges where Black plaintiffs, I mean, Mr. Evers in a case called Evers v. Dwyer, boarded a bus in Tennessee, not because he wanted to go somewhere on the bus, but because he was exposing himself to discrimination for the purpose of being able to challenge it. And for 65 years, we have assumed that testing is permissible in the civil rights context, including the ADA. So I think that's why a lot of people were really nervous about this case, both for its implications for the ADA and then also for civil rights more generally.
Okay, could you tell us a little bit about your client, Ms. Laufer, and what was it that she was trying to do?
Yeah. So Ms. Laufer was diagnosed with multiple sclerosis right at her 40th birthday, and her health deteriorated significantly. She now uses a walker or a wheelchair, and she found it virtually impossible to travel. For non-disabled people, the internet really revolutionized travel planning. We all can go on the internet at 10 p.m. at night and compare 5 different hotels and kind of think through what our options are. And although the ADA has been in place for 30 years and for over a decade, there's been a regulation specifically requiring hotels to provide accessibility information on their reservation websites. The vast majority of hotels were not complying with this as of 5 or 6 years ago. So Ms. Laufer got really frustrated. She couldn't get accessibility information. She found herself showing up at hotels she thought she'd be able to stay at, and then she had to stay in her car because they didn't have wheelchair ramps. And so she found out that this was illegal under the ADA and that hotels were required to make their reservation systems accessible to disabled people. And she decided she was going to do something about it. You can only get injunctive relief under Title III of the ADA, so no damages when she shows up and has to stay in her car, but she could bring forward-looking suits just getting injunctions requiring the hotels to add the information. So she started to work with a lawyer, and over the course of a number of years, she brought 600 lawsuits against hotels, and hundreds and hundreds of them ended up adding the accessibility information to their websites in response.
What is standing, and why is it an issue in this case?
Yeah. So if you don't remember seeing anything about standing in the Constitution, it's because what Article 3 actually says is that there's jurisdiction over cases and controversies. And about maybe 50 years ago, the court started to really kind of ramp up this definition of case and controversy. And so standing is the idea that courts only have jurisdiction if the plaintiff can allege an injury that's fairly traceable to the defendant's conduct and that is redressable by relief from court. So injury, traceable, redressable, and the question here is injury. What does it mean to be injured by a discriminatory denial of information?
And tell me how you think Ms. Laufer was injured by Atchison Hotels.
Yeah, I think that the easiest way to understand it is the seminal case in this area is a case called Havens Realty, where a Black woman and a white man worked together to test whether realtors were complying with the Fair Housing Act. And when a realtor told the white man there was an apartment available and told Ms. Coleman, the Black woman, that there wasn't one, they brought suit. And the question was, well, was she injured by that discrimination if she didn't actually intend to rent an apartment? And the Supreme Court in 1982 said, yes, she was discriminated against. There's a dignity harm there, right? Just the experience of confronting a sign on a door that says, no disabled people allowed. It doesn't really matter if you want to buy something in the store, you're experiencing a dignitary harm and a stigma from the discrimination. I think you can imagine if Ms. Laufer in her wheelchair went into a hotel lobby and they had a practice of ignoring people in wheelchairs. They had a sign that said, if you're in a wheelchair, call this number to make a reservation. We wouldn't think, oh, it's okay that she has to call a number. We would recognize that she's being treated as having inferior status. And that's the message when you go to a reservation website that doesn't seem to acknowledge the existence of disabled people at all as potential customers. That's really the day-to-day experience of being disabled in our country, is just it's not always kind of that direct animus. It's just this exclusion, and you're ignored. And so that was the discrimination. That was the dignitary harm, regardless of whether there was an injury from actually being able to stay at the hotel or not.
And what happened in the lower courts?
So I mentioned she filed 600 lawsuits, and single-handedly created a circuit split. I think it was 4-3 by the time she was done. So Deborah Laufer is the plaintiff in every single one of these cases, which is why I think her lawyer in the lower courts, that while we're on both sides of the circuit split, so we might as well acquiesce to the court's review. In this particular one, our case was out of the First Circuit. The First Circuit had held that she did have standing because she had been injured by the denial of the information that she was entitled to have.
What was the question presented to the Supreme Court?
So, the more narrow version that I articulated earlier, just this idea that does a disabled plaintiff who sues a hotel for failing to provide accessibility information on its website have standing if she doesn't plan to stay at the hotel? I should say, though, when I don't know if I made this clear enough before, I mentioned it's only injunctive relief. And what that means is if we don't allow testing, like what Ms. Laufer did, there really isn't a way to bring suit to challenge the lack of accessibility information, because by the time you have concrete plans to travel and you're going on the website to make a reservation, you're not going to say, oh, wait, accessibility information isn't there. Let me put my trip on pause for 2 years while I go to court and file a complaint and get an injunction, right? So the only way that this reservation rule, the regulation, gets enforced is by testers. So really what the hotel was attempting to do here was eliminate all enforcement of the accessibility information requirement.
The issue of mootness took up a good part of the argument. What is mootness and why is it relevant here?
Yeah, you alluded to this earlier when you said that this was a strange, the posture of this case is strange. So what happened, as you said, Ms. Laufer's counsel in the lower courts had acquiesced to the court's review. I didn't come onto the case until after cert was granted. And then after the opening brief had been filed this summer, we learned that one of Ms. Laufer's attorneys who had represented her in a different case in a district court, not involved in this one, but had been accused of some misconduct relating to his billing practices. And, it was one of those things where if you follow, hopefully folks who are listening who've read about this case were able to see some of the more recent coverage in the Washington Post and NPR and kind of understanding why these cases are so important. But prior to that, there was this really aggressive effort by the hotel industry and kind of corporate interests to villainize testers. You'll see if you Google Ms. Laufer's name, people referring to her as a professional plaintiff. Like she never made a penny off of any of these ADA cases, but you wouldn't know that from a lot of the coverage and the way they talk about her, the idea this is abusive litigation, but no one can actually identify what's wrong with a woman bringing, a disabled woman bringing lots of meritorious suits. There really isn't a dispute that these hotels are violating the law. But we then have these attorney misconduct allegations that aren't actually, related to the Article 3 question or the merits. But once that happened, Ms. Laufer, as you said earlier, John, she hadn't filed any of these cases in I think close to 2 years and wasn't planning on filing any more. When the misconduct order came down, she just didn't want to pursue this anymore. And so we were very transparent. We told opposing counsel, we told the court that she, was upset about this misconduct order and didn't want to pursue the case anymore. And she was dismissing her complaint with prejudice. What's tricky here is because the standing question is also a jurisdictional question, the court was still free to decide whether it wanted to reach standing first or to hold that it was moot because we had dismissed the complaint. And so we filed a suggestion of mootness in the summer. the court denied it and said it would consider mootness at the argument. The other thing that makes, Justice Kagan said during argument, the case was dead, 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 in all the ways something can be dead. She meant both that we had dismissed our complaint with prejudice. She noted also, as you did, that the defendant here actually sold the hotel before it filed its cert petition before the Supreme Court. So it has, like, the new owners would be bound by an injunction. The current defendant has no actual interest in this case whatsoever. It's really a mystery on why they were pursuing it. So I just say there are a lot of reasons to think that this case was not a good vehicle anymore for reaching the standing question, given, as I said, I think a couple of times during the argument, the parties before the court no longer have any legal interest in the outcome of the case.
So during the argument, there was a interesting admission of opposing counsel. He conceded that he didn't contest the concept of tester standing, and you mentioned before the Havens case, and he agreed that Havens remained good law. What I wasn't clear on is how he differentiated Ms. Lawfer's situation from a tester that has standing. Could you explain that?
I cannot. You're right that is what the defendant's position was. They were not actually able to articulate any principled line for why you would distinguish one, ADA testing from Fair Housing Act testing, and then two, they seem to recognize that you could have ADA testing if it was a challenge to a physical barrier, like the lack of a wheelchair ramp. But they kind of just said, well, you shouldn't have testing here. And I think that's why it made so many people nervous. There really wasn't, I think some people struggle with the idea of one disabled plaintiff suing 600 hotels that she doesn't plan to go to. But when you start to kind of think through what tester standing is and why it matters and what discrimination is, and do we think about kind of underlying motive when a person has a discriminatory encounter, there really isn't a principled way to distinguish what Ms. Lawfer was doing from any other sort of civil rights testing. And so they did draw a line, but I'm not sure it's one that actually makes any sense. And I think that's another reason that this case has been worrisome to civil rights advocates, because if the court were to draw that line, it would be very difficult to do it in a way that wouldn't call into question Havens or some of the other tester cases.
And then finally, so the government also participated in the oral argument and took a position that was different than each of the parties. Could you explain the government's argument in the case?
So the government's position was that in order to actually encounter the discrimination on the website, you had to actually engage with the website by attempting to make a reservation. And I said this during the argument, this is a novel question. How is a person experience discrimination on the internet? Can you just see it? Do you have to engage with the website in some way? And so our position was, when Ms. Lawfer visits a website, she encounters the discrimination when she sees the lack of accessibility information, in the same way if she visited a store and saw a lack of a ramp, that she would kind of encounter the discrimination then. The government said, no, you need to actually kind of engage in the process of making a reservation. But importantly, they did not say that you have to be making a reservation for the purpose of staying at the hotel. So they recognized that you could have testers for the reservation rule, but they would have to kind of actually make a reservation. I suppose they could cancel it, or so they were still leaving some place for testing. I think, we pushed back gently on that idea, mostly because I think it doesn't reflect the reality of being on the internet. I think if you were watching what Ms. Lawfer was doing when she was on the website, it would look very much like making a reservation, right? In order to figure out there wasn't accessibility information, she had to click on all the same buttons. So I think as a practical matter, it didn't make a lot of sense, but certainly the government's position was much more, I think, principled and palatable than what the hotel was offering.
So because you argue the case, I'm not going to ask you to predict it. It does seem like, a couple of things. It does seem like a majority of the court is prepared to find this case to be moot. And also, I think with that concession of opposing counsel, even if the court did reach the standing issue, it just doesn't seem like the worst of all our fears are going to be realized in this case, and that tester standing is going to survive another day. So I think
I like your prediction.
so I think for both of the first two cases, they could have been disasters. They're not. It's very unlikely they're going to be. The third case is more up in the air. Sorry, Leah, but I also will not ask you to predict what you think's going to happen, and that's Alexander versus South Carolina NAACP. And look, I'm going to ask you a non-substantive question first. This is your first time arguing before the court, and we were talking a little bit about this before the panel started. Could you just because most people that are listening in have probably not had the opportunity to be at council table or argue before the Supreme Court before. You talk a little bit about the experience of just doing that.
It's like nothing I've ever experienced before, to be sure. In many ways, you're prepared for it because you go through rigorous training by people who have appeared before the court or people who are very expert on the issues. But as we were talking about before I jumped on, there's nothing like standing in front of those 9 very powerful people who are very smart, where you want to make sure that in the time that you have, you convey the best of your case on behalf of your clients. And it's a pretty awesome burden, but well worth it. And clearly I would do it differently and better if I got another shot at it, but I'm proud to be on the other side of it, and I'm proud to have fought through it for sure.
Well, you did extremely well, even under the some of the what I will call cross-examination of a couple of the justices, particularly Justice Alito. You didn't concede an inch. So now
that was a reflection of the fact that we should be having a mini trial on appeal. I was willing to put myself in the line of fire for that, to send that message.
So tell everybody what's at stake in Alexander versus South Carolina NAACP.
Well, I love that Kelsey used the word dignity, because I think that at issue in this case, it's a racial gerrymandering case, is whether our clients, Mr. Scott, an individual plaintiff, and the members of the South Carolina State Conference of the NAACP, whether they have the right to a fair redistricting process that's free from race-based discrimination when the state, South Carolina, hasn't asserted a good reason for prioritizing race in its line drawing. It also is an important case because the state has sent a message to candidates and representatives of the district at issue, which is CD1, anchored in Charleston County, that they need not appeal to our clients or Black voters who are in the district, that their audience is the super white majority district that has been designed in the Charleston-based district.
So why should advocates of civil rights and racial justice care about this case?
For LDF, one of the key reasons why we got involved is because this isn't a case that arises in a district that is majority Black or close to being majority Black, but it nonetheless reflects at least South Carolina's belief that they can kind of do whatever they want with Black voters in the absence of having that statutory obligation, when in fact the Constitution protects against race-based sorting without a good reason, no matter whether that occurs in a majority Black or a non-majority Black district. So I think it's important for that. I think it's important because the state, at least by the time of trial, defends this map as being only a partisan draw. They only use purportedly partisan data, and they only did this for partisan goal. But our Constitution and the jurisprudence has been really clear that if you use the bodies and the of Black people as a means for even that goal, whether it be legitimate or not, that the Constitution finds that suspect. So I think it's important for that. And then again, I think every voter is entitled to a fair process in redistricting, and that did not happen in South Carolina when it redrew its congressional map in 2021, 2022.
So I'm going to ask you a couple of questions about racial gerrymandering. You've talked about this some. What is the Supreme Court's racial gerrymandering doctrine, and how has the nature of these cases and positions of the justices changed over time? since the court first found this claim in the 1990s.
So I think many people think it's pretty confusing, it's pretty complicated, but for our purposes, the essence of it is that you cannot excessively use race in line drawing without a good reason, such as complying with the Voting Rights Act. And by excessive, for our part, it does not mean that you consider race, that you're conscious of race, but that race is the thing that cannot be subordinated to other goals such as compliance with traditional redistricting principles or even partisanship in South Carolina's case. And it also means that race can't be a proxy for partisanship, and that race can't be, again, a means to achieve a partisan goal or any other goal. I think that's the heart of it, but it's pretty complicated. And I think it's changed in the sense that these cases, many will know, were originally brought to challenge majority-minority districts for much of the 90s into the 2000s. After the 2010 census, groups like who are civil rights, racial justice groups, and others have started to bring racial gerrymandering claims on behalf of minority voters to challenge the packing or cracking, oftentimes because of the misuse of the Voting Rights Act as an excuse for undermining Black voters' rights to a fair line drawing process.
Yeah, so it started out as a conservative doctrine, and the biggest proponents of it were the conservative justices. And now oftentimes the conservative justices are finding themselves taking the opposite position regarding racial gerrymandering claims, as the plaintiffs in these claims have changed. So last year, LDF argued a case, or your colleague Dewell Ross argued a case involving vote dilution, Section 2 of the Voting Rights Act. What is the difference between racial gerrymandering and vote dilution?
There are big differences that the court has recognized, and I should note that we do have a vote dilution claim in our case as well, an intentional vote dilution case, but these are analytically distinct claims. The racial gerrymandering claim asks whether there's been a significant sorting of voters on the basis of race, and is there a compelling reason for it. It asks the question of whether race was the driving factor, and it doesn't care about the electoral implications of race-based line drawing. By contrast, the vote dilution, whether intentional or as a result, line of cases is looking at whether or not there's been, in our case, a purpose to design a district with the purpose of minimizing the electoral power of a group here, Black voters. We have both of those claims. The intentional discrimination claim, again, also requires only that purpose be a purpose, and that there be some injury, and you use different evidence, sometimes overlapping, but also distinct evidence in order to prove the claims. So we like to say that in our case, race was the means for South Carolina to achieve its partisan goal. Excessive use of race was their means to achieve their partisan goal, but they also had a design to crack Black voters out of this district in order to reduce their electoral power, even as a way for them to hold on to power. They're reconcilable, though distinct claims.
So the way that I understand the facts here is essentially you had a situation, you had this district in Charleston that had, mostly in Charleston, that had, among other things, elected a Democrat under the prior plan. You had Republicans controlling the legislature and the governor in South Carolina. They wanted to keep the district Republican, make it stronger Republican. At the same time, they wanted to add some of the counties outside of Charleston to the district. The downside from the perspective of the people behind the plan is it increased, by adding those counties, it increased the Black population. And so they had to take a large number of voters outside of Charleston, and they had to be disproportionately Black in order to have the same racial demographics as the prior district had, right? So it's a combination of of racial and partisan partisan strategies involved here. One of the other things that most people aren't aware of is that when you bring a racial gerrymandering claim involving a statewide redistricting plan, you do it in front of a 3-judge district court that's comprised typically of 1 appellate judge and 2 district court judges, and there's automatic appeal to the Supreme Court. There's no intermediate appeal process, and you won on the racial gerrymandering claim related to the CD1, which had been predominantly a Charleston County-based district. And so this case comes up to the court. There's no intermediate court of appeals. Much of the argument focused on the clear error standard. What is the clear error standard? Why was it relevant to this case?
Well, the clear error standard, as I understood it prior to coming into the argument, was that there's a lot of deference at the appellate level to the factual findings of the 3-judge court, and the racial gerrymandering finding is a finding of fact, as are the subsidiary findings, such as that race was a better predictor than partisanship for the sorting of voters, that those findings have to be given a lot of deference, and they can be reversed if there's some firm belief that some serious mistake has been made. Not that this appellate court would render a different decision if they were to look at the evidence new, but has some serious mistake been made? And does the entire record that the trial court assessed over, in this case, an 8-day trial featuring about 40 witnesses, including half of them live, 6 experts, is that total record plausible? And some of the facts that you just talked about, which is that the fact that they were moving Black people in and out as if they were a monolith, the fact that the racial population of the district remained exactly the same, even though they were moving close to 200,000 people, the fact that we had unrebutted expert evidence, all of this were considered by this panel, and all of it led the panel unanimously to find that in total there was racial predominance, and it cannot be explained by compliance with the Voting Rights Act. All of that's supposed to be given great deference, and the appellate court's not supposed to have a mini trial on appeal as if they were looking at the evidence anew.
And probably if you and NAACP are going to win this case, it's going to be because of that clear error standard. So at its heart, this case involves the issue of redistricting that was infected by both racial and political interests. The racial part can be a violation of the law. The Supreme Court said in an earlier case, Rucho, that partisanship is, you can be as partisan as you want, and that's not going to violate the law.
Under federal law.
Federal law, correct, yes. The U.S. Constitution. The Supreme Court's racial gerrymandering standard typically requires plaintiffs to show that race predominated over traditional districting principles. Doesn't mention partisanship. The case that deals most with the issue of race versus partisanship can be read in different ways as to how the issue of partisanship fits in a racial gerrymandering analysis. Okay, now you've just argued this case, thought about this a lot. How exactly should the court assess a partisanship defense?
Well, first, I think the law is clear that the plaintiffs have the burden of showing that that race was the primary consideration, and so here we have a ton of evidence that race was the predominant consideration. In recent jurisprudence in Cooper, out of the North Carolina case, as well as if you look back to the Cromartie case, also rising out of North Carolina, when states have offered up these partisan defenses, they have asked plaintiffs to prove, to show that partisanship isn't masking the racial impact, and vice versa. And so people have proposed maps as an alternative that show that you can achieve that partisan goal without having the excessive use of race. And in our case, much like the Cooper case, we had experts disentangle, look at the movement of voting precincts and determine, based upon the racial makeup, based upon the political data point that the state said that they were using, like which one more explains the design. And this is complicated because we were able to show it here and we were able to disentangle, but there are surely going to be places where race and party are so wound up that it will be hard for plaintiffs to show one more than the other. I think from our perspective in such a case, we'd say that race, if you show that race was a significant factor in the sorting of voters, that may be enough to prove a racial predominance claim. But I think it's a thorny and tricky issue. I think we're fortunate here where we have the tools that have enabled us to disentangle the two. But going into this case, we are very clear that this case may not be like other cases, and we may have stronger evidence than other plaintiffs may have. And that's why we are encouraging the court to make clear, as it has before, that there's no particular way to prove racial gerrymandering. There are lots of different ways. And we need to have, as civil rights plaintiffs, various methods in order to prove what we think is happening in the line drawing. But it's complicated and very difficult, to say the least.
Last question I'm going to ask you. Chief Justice Roberts focused on the differences between this case and the others where the courts found a racial gerrymander. What do you see as the similarities between this case and the prior cases in which the courts found a racial gerrymander, and why, in your view, the similarity is more important than the differences?
So you're asking me a question that I have since woken up every day since my argument last week to be like, this is what I should have said. There's a colloquy with where both Justice Roberts, with myself and with the person arguing for the state, sort of says your case doesn't have direct evidence. It's all circumstantial evidence, and there's this wealth of political data and so forth. And is there a case like yours that's just largely predicated on circumstantial evidence? And I invoke Gamillion because Gamillion is a case where the plaintiffs only had circumstantial evidence, and if the court had required direct evidence, plaintiff would have lost, which we know would have been a ridiculous outcome given the facts in that case. But what I should have also added is that our case is very much like this court's Cates and Cooper from 2017. Our panel was very aware of Cooper and I think had studied Cooper scrupulously. And while that case had direct evidence where a congressman talked about the role of race and how they had ramped up the Black voting age population in a district, while we didn't have that here, we had other evidence that is comparable, if not as strong as that case. And more importantly, this court should be, if it's consistent with how it treated legitimate goals like diversity last term with how it's treating the legitimate goal of partisanship this term, it should recognize that you can have those legitimate interests, but you cannot get there in an illegitimate way. And here, using race was the illegitimate way that they reached their partisan goal, just like the court, from the majority's court's view, viewed diversity last term, that was using race was an illegitimate means to get diversity. So I would have answered that question very differently, but I think our case is not that unique, and I think you can look to Cooper. And frankly, people have been using partisanship as a way to manipulate Black voters since we have had access to the political process in this country. So I don't think we have to look that far for cases that make clear the harm here, and that this court has to step in and address it.
Yeah, and both parties have used race in the process of coming up with redistricting plans. Thanks, Leah. I'm going to have a couple of questions. I'm going to bring everybody back in. I have a couple of questions for all the panelists. If you have questions for the panelists, please use the Q&A function. And if there are questions for the panelists, we'll go to them after I ask these couple of questions. All right, so I'm going to ask them in the reverse order that I laid them out earlier. The court has moved away from the traditional hour-long arguments and to arguments that are much more lengthy. Leah's, for example, went almost 2.5 hours, And I say that because I was late for a 12:30 meeting because we were talking about it, talking about the argument for a few minutes after it was over. How, if at all, has that changed the preparation for and the significance of oral arguments?
Well, it means we know we learn so much more. Everybody learns so much more from oral argument, right? We learn what each of the justices think in some depth, and we never used to learn what Justice Thomas thought in to any significant degree. So it means also that the justices aren't jumping all over each other quite as much, and so you don't have to fight quite as much to get a word in edgewise. So I think that I hated this new format at first, and now I love it. And I think it allows the justices to get more to the heart of things and allows you to really make your argument that you want to make instead of focusing just on kind of the quick soundbite answers. And it also means, I think Kelsey was mentioning this earlier. I'm curious what you think about this, like this initial block of time that you have at the beginning under the new format is really significant because you have these, couple minutes where you can say exactly what you want and you're going to get it all out. And so you can really frame the whole case and maybe you're speaking there. I hadn't really thought about this until you mentioned it, Kelsey, but maybe you're speaking to people beyond the court sometimes when you do that.
Yeah, I'll say I love it too. One, for the reason Deepak said, like I remember preparing for an argument before the pandemic. So for folks who don't follow the court as closely, this was a change that kind of occurred over the pandemic. First, arguments switched to phone, and they decided that each justice would get an opportunity to have a couple of minutes. And that's when Justice Thomas first started participating. And then in a post-pandemic world, they've kept the so you still have the kind of the back and forth with the hot bench, but at the end, each of the justices gets an opportunity to ask any questions that they haven't gotten to yet. And what that means, as Deepak said, is that they are not jumping over each other as much during the argument because they know they're going to get a chance to ask their questions later on. And the kind of the stylistic piece of it is so different. Like I remember pre-pandemic, part of preparation was being able to get your thoughts out and pivot without taking a breath, because they tend not to interrupt you if you don't actually take a breath. But if there's even a split second of quiet, they're going to jump in. And so I remember during, I'm thinking of an argument in 2018 where I would be talking just like I am now, and then I would go because so you had to be thinking ahead of what it was you needed to get out. And it felt like as Deepak said, like to get a word in edgewise was so difficult that it took away from being present in the moment and being able to really just listen to the question, take a breath, answer it. So I think it's terrific. And then the 2 minutes at the beginning, the first time I got to do that was also during the pandemic, an argument I did by phone in a case called Torres v. Madrid, which was a police brutality case under the Fourth Amendment. And I thought a lot about the fact that I wanted to name what had happened to my client in that case, which is that she'd been shot in the back by police while she was driving away because she thought they were trying to carjack her, and she ended up taking herself to the hospital. And if I didn't know that I had those 2 minutes, I think I would have been less likely to talk about that because it would have prompted someone to interrupt me. But there was space for me to spend just 15 seconds naming what had happened to her and her terror in that moment. And also, at that point now we're live streaming, it's on C-SPAN for people listening to understand what was at stake. So I think all this is just a terrific development. I'm delighted that Justice Thomas is participating as well. He often sets the tone for kind of the direction the argument goes in now, and his questions are generally really, they're really thoughtful and, as Deepak said, help you understand kind of what they're thinking in a way that we didn't before.
Is that can't they just send us a list of some of the questions they actually want to know that we can talk about in advance rather than what is largely a guessing game? And
that's the next big development. Let's push for that next.
Well, in your case, it would have been a long string of questions from Justice Alito because as when I was reading through the transcript today, as I told you earlier, there were 11 consecutive pages of question answer between you and him, and we certainly would not have seen that.
I think that's what's called a deposition or an examination at trial. I mean, that is not what we expected oral argument.
All right, one other question for you all. We know that the court's the most conservative that it's been in decades, but beyond that, what are you finding notable about the court right now?
So I think that it is the most conservative court in decades. That's certainly true. But I also think that we often focus exclusively on a small number of cases where the ideological valence of the case is really clear to people. And so I think that what that obscures is that this is a new court, a new collection of people together, and we often don't really know precisely what they think about a lot of things. And so it's actually the most unpredictable Supreme Court that we have had in the 2 decades I've been practicing, at least. And on a lot of issues that affect consumers and workers and the kinds of clients that I represent, there are actually opportunities. And so I have to constantly tell myself not to have a kind of knee-jerk reaction to the court. I mean, I'm usually still filing briefs trying to keep cases out of the court and trying to protect lower court victories, but there are also opportunities. And that to me has been the most surprising thing about this court.
Yeah, so my practice after Justice Ginsburg died and I moved to ICAP is focused almost exclusively on defending civil rights victories in the courts of appeals from Supreme Court review, because although Deepak's right, they're here and there, we might be able to get 5 votes for the position we like. It seems like a good use of my time to just be focusing on keeping cases out of the court. Much easier to keep them out than it is to get 5 votes once they're there. And so I watch all the civil rights docket really carefully. I know pretty much every cert petition that's coming up on the other side. And I think what's surprising is how many of the cases they're passing on and not taking, right? Like when a case goes, there's a cert petition and it gets denied, that doesn't make news necessarily in the same way. And I think what that reflects is that, I mean, lots and lots of cases. I mean, and some of them will get kind of rescheduled a couple of times or redistributed. So it looks like they were having a conversation and then suddenly they're denied. And so, we have 6 justices who, kind of labeled conservative. They're not a monolith. Like there's something going on there where we often will see Justice Alito and Justice Thomas and Justice Gorsuch dissenting from the denial of review or doing some sort of concurrence. And so I tend to think, and this is maybe overly simplistic, that the 3 of them are more likely to vote in a block, although not always. And then you have Justice Kavanaugh, Justice Barrett, and the Chief, who and maybe this is an overgeneralization, but I think of as more as institutionalists. So one thing we've seen post Dobbs is I think they've been much more careful about taking civil rights cases that maybe there would have been an appetite before in the qualified immunity space, for instance. So I tend to, as Deepak was saying, remind yourself that sometimes you take cases to court. I don't really do that, but I do remind myself, none of these cases, even if it's a circuit split, even if it's a controversial issue, are necessarily ones that the court is going to take. They're making calculations in their conferences about which ones they want. And it could be that there are 3 that want to take one and they can't get the 4th vote. So there is space, I think, to be doing important work before the court, even if it's harder than it was before.
Come at this from a very different posture where I'm, got to take my case up to this this group of people who I do pay attention to, obviously, but I do not study or think about as much as I have in this short period of time in prep. And so I think my comment's more just about how, we have the fortune of being on this call with people of color, women who are appearing before the court or regularly appearing before the court, and how eye-opening this has been about just the narrowness of the voices that appear before the court and how much that needs to change. I mean, I really had to reach out and lean on people who appear before the court often and who could provide guidance, but they're just not enough varying voices. And I felt that. I felt, when I was standing up there, I don't sound like a lot of people who appear before this court. I don't articulate myself in the same way that other people do before the court. I don't, there's just so many things that go into this that need more. We need to just expand this opportunity for people, and we need to expand sort of how the court sees itself and who it sees itself having to hear from in these settings. And I think that's a big lesson from me through all of this.
Well, Leah, you got the last word other than from the moderator. And my last word is to say thanks to our tremendous panel, Deepak, Kelsey, and Leah. We'll be rooting for you as these cases come down in the next several months. There are going to be some additional cases this term that implicate civil rights and racial justice issues. They're the so-called Chevron cases about the government's authority under administrative law. There's also going to be another case this term, net choice, involving government regulation of the internet, and probably some others before we get to the end of the term. And we will probably be doing, Lawyers Committee will probably be doing at least one more of these panels, probably at the end of the term. I also want to thank my partner in crime in terms of putting this together, Carlita Salazar, who is our VP of Comms, and be expecting other virtual events from the Lawyers Committee in the months to come. Thanks for taking your time this afternoon to listen to this, and we'll be back in touch soon. Thanks, everybody. Good night.